What we are trying to say.
But here one more point is there. In Evidence Act 145, Section 145 is there.
Oh, Miss, that
No,
145 will apply when the trial is being conducted. Then
that is true.
but this is not a trial.
No,
so you cannot contradict. There is no witness to be contradicted at the time of constitution of bail. If the report has been prepared under 173,
yes,
then you cannot look into the case diary. Now come to the second proviso. Provided
that such accused person shall not be released on bail or on his own bond if the court, on a perusal of the case diary or the report made under section 173 of the code, is of the opinion that there are reasonable grounds for believing that the accusation against such person is prima facie true.
Okay. Now, we will not go to other aspects of this proviso.
Yes.
Only thing, what the proviso provides is that he shall not be released on bail, number one. When he shall be released, if the court is of opinion that there are reasonable grounds for believing that the accusation against such a person is prima facie true, how does the court come to that opinion? On the basis of consideration of the perusal of the case diary or
report.
Now, if you say therefore A or B,
A case diary,
B report.
Report is charge sheet.
173. Now, when you say case diary contains everything.
Yes.
Case diary is all the observation, whether admissible, non-admissible, immaterial. Case diary means is a compendium of the facts, observation made by the IO during the investigation. That's case diary. Case diary does not say that, no, if the evidence is not admissible, you shall not enter in the case diary. In fact, he will enter everything. His opinion, he thinks, what he observed. Whatever he thinks is relevant, will record it. It may be, ultimately may not be admissible.
Yes.
That's a different aspect. But he will note down everything. So the case diary, when we say case diary, it contains all facts which may be admissible, may not be admissible, which may be relevant, which may not be relevant. It is for the court to decide later on. Now, but nevertheless, the fact remains as case diary contains all these facts, all bunch of facts. Number one, 173. Then there is some application of mind by the prosecution also. Oh, this we don't want it. This is perhaps necessary. Perhaps this is relevant. So there is some application of mind by the prosecution before it is laid, report is submitted. Because you apply your mind. We have conducted this investigation. And now this is our view. Now these are evidence. So and so now we want to charge him for committing this offence. That's in substance 173. And obviously they would not normally include things which are not admissible law, though they may also include it. But then that is for the court to just to separate it. Okay, no. These are not relevant. These are not admissible, whatever it is. But then nevertheless, there will be some application of mind by the prosecution also. Oh, these are the evidence which will stand the scrutiny of the court. They may be right, they may be wrong in their assessment. It is for the court to decide. But there is some element of application of mind when you make 173. Therefore, in the process, you normally do not take into consideration which you think that this is plainly illegal. Normally. So, what the difference between A and B is that A contains everything. B contains normally, which is permissible in law. To some extent, there has been some filtration has taken place before you make a report under 173. But UAPX says either A or B. If you take A, it may contain many more damaging material against the accused, though it may not ultimately stand the scrutiny of law. It may have various, evidence, recording of facts, observations, That is case diary. So, if you look at case diary, he will be more prejudiced.
But then again, Lordship will apply the law.
No. That is what we are coming. Now, but when you say 173, you see, it has gone through some filtration. But when you say case diary, pure simple evidence, whatever the whatever the IO has collected,
Yes, legally, illegal. What?
legal, illegal, which includes 161 statement,
Yes, which are not.
which
yet.
says all, he's saying all kind of things. Then the prosecution is, the defense saying, no, this court cannot look into it because that 161 cannot be linked to it because of interdict of 162. Fine, but that is at the stage of
Trial.
trial.
Not now.
We are not in trial, we are in bail. He is also, the defense has been able to point out so many defects, which creates a doubt on the genuineness of the confession, voluntariness of the confession.
Now,
So-
whether those will be considered during this bail,
Ah,
because here otherwise, by leaving
otherwise,
this proviso, it
yes.
will not include.
So
Either
therefore,
testimony or report.
therefore we'll ignore whatever is happening in the trial, according to you.
Not according to me,
Huh?
from yes,
No,
from
no,
the,
no, I'm not saying according to your view,
yes,
is that
from
it will
the
be totally ignored.
yes, from the provisions of the this proviso, because it is case diary or a report.
What we are trying to say that
But
you will be
here
happy.
one more point is there. In Evidence Act 145, section 145 is there.
Oh, Miss, that
No, no,
145 will apply when the trial is being conducted. Then
That is true.
but this is not a trial.
No,
So you cannot use, you cannot contradict. There is no witness to be contradicted at the time of consideration of bail.
During investigation, something he has to brought before the court. And if he bring these things, in that case, that must have to prove. If he cannot prove that thing, in that case, this cannot be used against the accused.
Correct, but then the contradiction has to be with the witness, not the document as such. The contradiction for contradicting, the contradiction must be of the witness who is testifying.
Yes.
That stage has not yet come. In the bail stage, we don't examine witnesses, only the documents, materials, case
Yes.
diary.
What documents they have produced, Lordship, in this case, against the accused person?
Correct. We'll see that. That will take a appraisal. Will make an appraisal of
As
the.
per proviso, what my understanding is that if proviso, if we go, then there are two conditions. One for case diary and other for 172.
Correct. But then the law permits both.
No.
It doesn't say case diary, and in absence of which, or the law is it gives option to the court to either use case diary or the police report. If you are able to show
Yes.
with some decision that
Yes.
once report has been prepared,
Yes.
you cannot look into the case diary. Then is another thing. The report has been prepared under 173.
Yes.
Then you cannot look into the case diary.
If court cannot take it as evidence during the trial, the use of this, nothing, Lord. That is why if final opinion submitted by the IO under 173, the 172.
Therefore, we are saying that you cite the judgment that
Definitely.
once a report is prepared submitted under section 173 of CRPC, the case diary becomes redundant. Therefore, even if the act says case diary or the report, we must look only at the report, not in the case diary.
And
Because case diary has lost its value.
yes.
It has been already scrutinized.
And one more thing in 170.
We have to argue in that manner also. Then
yes,
we
Lordship.
can perhaps look into the aspect.
Lordship, in 170 to 1.3, subclause 3, one more thing is there. Neither the accused nor his agent shall be entitled to call for such diary, nor shall he or they be entitled to see them merely because they are referred to by the court. But if they are used by the police officer who made them to refresh his memory, or if court uses them for the purpose of contradicting such police officer, the provisions of section 161 or section 145, as the case may be, the Indian Evidence Act.
There is no doubt about it. There is no issue. But that is not at a time of consideration of bail. There is no time. That is at a time.
This is not mentioned in anywhere because
then you argue on that. We are giving you that. We are not saying that you are not what you are submitting is not correct. These are all probable areas. You argue that yes, what is prohibited by law Yeah, even if it is contained in case diary, cannot be used. According to it is prohibited by law.
Yes.
Huh? Under 162.
Yes.
Huh?
Hmm.
Therefore, even if it is found in case diary, the court should ignore it. Then case diary loses its value. Therefore, the court should go look into the 173. That has to be your argument.
Yes. I
This
have mentioned it. I have mentioned that too.
Oh, you have mentioned, we are also saying,
Yes, Lord.
but no, we are not deciding it.
Yes,
But
yes.
that can be the argument which you can put.
Yes.
But show some judgment if you have. That's what we are asking.
Definitely, Lordship. Because of Lordship query, yesterday I bought this question.
Otherwise, you would have bought it. Huh?
Other,
But without it, how will you be a practicing a lawyer?
otherwise, we have this one.
Only this will suffice.
New edition. This is new edition.
You should always buy the latest edition.
Yes, yes, new edition.
See, we are trying. See, R.K. Dev Chaudhary. When bail is considered at various stages,
Yes.
when a complaint is filed, investigation started, then the picture is not clear. Still, people say, no, there is nothing. There is nothing in the FIR, nothing. The police has done investigation. He has arrested so and so, but nobody has implicated me. So kindly grant bail. That's the usual in bail. Nothing has been said. He is the main accused. He has not even mentioned my name. So much thing has been recovered. But nothing to implicate me. I am unnecessarily being dragged. Please grant me bail. Then we look into case. They call for the police report. The police will submit the objection, bail objection. They will write on the basis of investigation they have done. So and so, so and so, so and so. Then the court will look it. Okay, grant. Okay, reject. But when the trial has started, then he said no, and nothing. Even during that 227 charge consideration.
Yes.
There also
228.
228. There also he is entitled to ask. See, there is nothing. Though so many things are written against me in the case diary, no value, no worth. All are confessional statement made to the police in custody or to the police, all inadmissible under section 25 or 24 of the evidence.
25 to 26.
I said, therefore,
Evidence.
no case, throw this out. Acquit me. Or if you want to, at least grant me bail. And nothing, no material.
Lordship, the interpretation would differ from stage to stage.
That is what we are asking.
Yes.
What is the fact? Fact situation now today is a trial has commenced. Trial has commenced on the basis of certain charge sheet framed. Charge sheet is framed on the basis of certain evidence. Whether these evidence will be sufficient in ultimately to sustain the conviction is another issue. We are not called upon to examine.
Lordship.
We are only called upon to examine whether to grant bail to this person or not. To consider it, there may be some material which we have to look into. What do we look into? Case diary mentioned in the section provision to section 43 or the police report, because these are two different documents. Case diary is a bundle of whatever facts gathered. Relevant, irrelevant, admissible, non-admissible, all bundle of facts, case diary, all bigger, truckload of bundle. And when you reduce it to charge frame, you also, screen out all those and thin down. The volume is thin down. When you file a charge sheet from truckload to a car load only. Because you feel that these are all unneeded. Though we had considered, but no. Not relevant, useless, this, that, reduce. More, actionable evidence.
Which
Because
can be established.
You think that because of this evidence, we'll be able to convict Nargis and send her to jail. That's what you are confident. That's why you file. It goes through all various channels. Prosecution applies, director approves, sanction. Everybody applies their mind. Okay, very well. These are documents we think will sustain the charge against Nargis. Charge sheet is filed.
That should be applied for under section 145 of Evidence Act. That is.
Madam, you are again.
Discussion. I'm telling this.
Why you are bringing 145 again and again?
Again and again, Lordship.
Because in bail we don't examine any witness.
No. What document they will rely?
Arey Baba, unless you cross-examine on that by pointing out those facts, what you state in 161, how, what,
That is the thing. Lord.
what the,
That document they have to rely in their final report.
oh, again, you are making yourself confused. That state has not yet come for purpose of bail.
That is not mentioned in the section, in this section.
Lordship,
That is not mentioned in the section. In proviso, two things mentioned. Only the
Oh,
report.
just because it's not mentioned, that doesn't mean that you can use it, because that is to be used, that 145 is to be used only during the trial, when you confront the witness, saying
No,
that you are,
only thing.
when you confront and contradict him.
Lordship, I'm not on that. Only thing is that if they file any document, that document must have to prove by them.
Oh,
That
they
is
prove,
why-
of course.
that is why they have to file the documents which can be reported under section 145 of Evidence Act.
Oh, that is their problem, their headache. Why you bringing? You cannot bring at this. You cannot argue on that.
No, that is
That
why-
that is the
that
stage.
is
That
why-
is not the stage in bail that you can argue on that. That you can argue later on.
No, Lordship, it's a case after filing of charge sheet.
Whatever it is. So, what are the materials which can be looked into by a court while considering bail? It is the issue before us.
Lordship, let me look into few high court decisions. Of course,
Yes,
Supreme
please
Court
do
I have got, but this is not very clear. It only lays down the law.
Please do that. Please do that. Because it is very important also. We feel that it is very important.
Here it
Because
goes-
if we look purely on the case diary, there are so many material against you.
So then Lordship has to look into everything. Lordship cannot skip.
That's what, see.
That's
See, R.K. Dev is saying, see, Nargis, R.K. Dev is saying, this court has to look to case diary, everything what is there in the case diary.
Lordship, one more thing I found.
Because the law says so,
No.
case diary or,
One more thing I found. The court is entitled for perusal to enable it to find out if the investigation has been conducted on right lines. 172 is like that.
or that is before the,
Not
But
for
that-
using up against the accused.
Investigation. We are considering bail after charge with evidence, but 172 is investigation. stage.
investigation stage.
Yes,
Sometimes police may go here and there.
yes,
Uh,
yes.
yes.
Now the case is after.
So you argue, Nargis, we have given you sufficient hint to you.
Yes, yes, definitely.
We cannot go beyond this.
I'm very much
Because
obliged to that.
hint in the sense, because these are issues which is also in our mind. What is to be done? What are the documents? What are the materials which we can look into at a time of consideration of bail?
This is perhaps an area, Lordship, I have not come across any judgment of this honorable court, at least on this point.
No, fine. Then you assist us to make a good law on that, because see, whether he gets bail or not, it now on certain principle of law, it must be so. The principle of law must be clear. Then whether he gets or not, that is another issue. That is the application of the principle. But what principle we must evolve and we must adopt, we must apply, that must be clear to us. If there is some vagueness in that, let it be clarified. We feel that there is some element of vagueness, ambiguity in this
This provision.
proviso, in
Yes.
this proviso.
Yes, sir.
What yes?
Yes, I got it.
Do you do some homework on that?
Yes, I'm doing Lordship.
Huh?
Still, I'm searching in this Lordship.
And do some homework.
Yes, Lordship.
Spend some more time with Durga Puja. Uh,
Again, I'll look into
Huh?
Again, I'll look into that.
Please do that, because this is what we felt is a very important area.
Yes.
Because
To that regard, I talk with her lots of time, Lordship.
Yes, so she told me about this.
because this principle, we also want to be more clarified.
Had it
You want
been
more
not-
clarity on this.
Yes. Had it been not a or, if
Yes.
Or-
had it been a comma,
Comma,
then
huh.
he could have applied adjustive generis and then apply everything.
Yes.
Yes.
Case diary, final report, the documents that have come during the trial,
Yes.
everything would have been included. Had it, we could have.
And whatever provision of law must be in tune with the basic constitutional safeguard.
Yes.
It must be in tune with the basic constitutional norms also. And the general criminal jurisprudence of the country unless the wording, the language is very, very categorical,
Yes.
unambiguous.
No
If it is unambiguous, the question of
Ah.
again bringing constitutional norm, this and that may not arise.
When there is
But
no
if there is
mistake,
ambiguity, then what kind of interpretation we adopt? We must adopt that interpretation which is in conformity with the criminal jurisprudence, which is well accepted, well settled.
here it is very clear, case diary or report.
Is there a
Now the
report?
question is, after filing of report, no case diary.
Yes,
That has to be again interpreted.
yes, yes. Can you still look into case diary once the report has been filed? Because by the time report has become redundant,
Yes.
in law, the case diary has no more value. Once till investigation stage, case diary has all its importance, significance. The moment say yes, report has been prepared, the case diary goes into background. It goes to the background. Then if that is which is gone to the background,
Whether that
can you retrieve it? Saying no, I want to see the.
Yes. Or whether the subsequent depositions could also be considered. That has to be again.
There again another issue.
This issue raised by your lordship earlier also. This regarding this consideration of the deposition of witness or not.
What did you? I raised it, but
But I
have you
will
given
reply-
any answer to it?
Yeah, no, lordship, because their turn. I will reply to
What
that.
is my their turn? It is your duty also to
Definitely,
see
I'll reply to that.
what you are not replying also.
Their turn not yet completed.
But this is a legal issue which we also have to
Yes, sir.
address.
I talked with Ms. Jahan to that
Yes,
regard.
she
Yes.
spoke to me.
Lordship, our expert here is, so we all look forward to her.
Highly obliged.
Now we want to see some more clarity on this issue.
There will be some. There will be some.
I am sure there must be some. See, if we flip through, there are thousands of cases being decided in this country in lower courts. No,
In
even
other
though
courts.
even though it may not be UAP Act,
Yes,
it
yes.
may be some normal act. So somebody may raise a question. No, Your Honor, you cannot look into this. How can you look into this? Now is a trial stage. How can you look into this case diary? It has been discarded by the prosecution. Only adopt a certain portion of it. That's how they have filed this charge. Therefore, you can't look into that abandoned house. You have to go to a new house, which have been adopted by the prosecution. That is an old house, old farmhouse. The prosecution has built a new house.
I think there is a similar provision in Tada, Kota or somewhere.
Yes,
See,
yes.
see.
This 43
I
T5.
found
What? Yes, again.
Lordship, I found in this book, but little bit time is required.
So you take your time. If needed, you buy more books.
I mean, vacation. there will be no vacation for us because of this case.
Good for everyone.
Okay.
Okay then.